for your willingness to participate in this. We welcome anyone from the general public or the media that is watching our live stream on the appropriate YouTube channel. As this is the second day, we had a day last week with 3 cases and today of 3 cases in which our court is conducting oral arguments by video conference as a way of addressing and moving forward the needs of the judiciary, while we also protect the health and safety of all the folks involved in our justice system. So we're very happy to be able to do that. It seems to have worked well. Even though it does work well, we also realize that this is not a perfect process. And we certainly don't expect the lawyers to be perfect in this, and nor will we be perfect. So we will do the best we can not to talk over each other and to try to identify who is speaking, so you as lawyers will know which justice is asking the questions. And we will begin in just a moment. I would remind both lawyers that the appellant each side will have 30 minutes. If the appellant wishes to reserve any time for rebuttal, please do so at the beginning of your argument. All right, Mr. Clerk, please call our next case.
State of Tennessee versus Robert Jason Allison.
Good morning, Your Honors. Richard Strong here on behalf of Robert Jason Allison. I'd like to reserve 3 minutes for rebuttal.
All right, thank you.
Your Honor, we're here today, Your Honors, we're here today on a money laundering case involving Mr. Allison. Count 5 of the indictment that Mr. Allison was convicted under alleged that he engaged in money laundering on January 13th, 2009. And count 6 of the indictment alleged that he engaged in money laundering on January 20th, 2009. At the trial of this matter, it was presented that a confidential informant of the Metropolitan Nashville Police Department engaged Mr. Allison in the purchase of marijuana. At the first purchase, Mr. Allison fronted or provided drugs to the confidential informant on credit, allowing, and then the confidential informant came back on the January 13th date alleged indictment and repaid the money for the drugs that had been fronted at the original transaction. On a second transaction, he again fronted drugs to this confidential informant, and the confidential informant again came back on January 20th using money provided by the Metropolitan Nashville Police Department to repay the money for the fronted drugs. The evidence presented at trial in regards to the dates alleged in the indictment against Mr. Allison of any type of financial transaction was that repayment of drugs. It is our contention that this is not a separate financial transaction that can justify a conviction under the money laundering statute, but rather is the completion of the original sales contract that occurred at the dates of the transaction where the drugs were fronted. In the record, there is no evidence that any additional financial transactions were made by Mr. Allison on the dates alleged in the indictment, merely accepting the repayment for the drugs that had been fronted. It is our position this is not a separate financial transaction. This is the completion of the sale, and our position is that the money laundering statute requires evidence of a separate financial transaction for some dispensation of those original proceeds to support Mr. Allison's conviction.
Mr. Strong, this is Justice Page. Does that really make any difference as long as the transaction that took place fits the statutory elements of money laundering, which are proceeds of one unlawful activity used to promote or carry on another unlawful activity?
Well, there's no evidence to promote other unlawful activity on the dates alleged in the indictments. This is merely accepting payment for the original sale. If that was the position, then any dime bag transaction in which the person made a profit off of it could be charged as a Class B felony. I don't think that's the intent of the money laundering statute. Rather, it's to punish people for using the financial proceeds of the illegal activity to do another transaction, not to just accept the money for the initial illegal activity.
Mr. Strong, this is Justice Bivens. But in fact, haven't a substantial number of federal courts found that the very similar federal money laundering statute applies under very similar facts to the case of this one?
They have, Your Honor, but I would say the statute cited by the state in their brief, I believe it's Warshak, that was dicta. That wasn't briefed or provide, but it is what the courts have said. Yes, I can't deny that.
Mr. Strong, it would appear that assuming that this money was used to buy drugs, future drugs, only a small amount of money would have gone to that purchase under these facts. Is that correct?
There was, when Mr. Allison was arrested on the 21st of January of 2009, this has been a long case, there was a substantial portion, almost $2,500 of the provided drug money was found on his person.
Does that matter that it would be, assuming it did happen, a very minimal amount of money? There's evidence of only a minimal amount of money went to purchase of drugs, or is $1 sufficient?
Well, my argument would be if the indictment had alleged that on Diver's date between January 13th, 2009 and January 21st, 2009, he had engaged in some form of money laundering, then I would say I would argue, but that's not what the indictment alleged. The indictment alleged that he engaged in money laundering on the 13th of January and the 20th of January.
Mr. Strong, this is Justice Page. On the second transaction, I believe he was, he fronted $3,500 worth of marijuana. And then when he was arrested the next day, he had $2,460 of $2,780 that was marked that actually came from the Metro PD. Those facts are correct, aren't they?
That is correct, Your Honor, yes.
And of course, I think Justice Lee was alluding to the drugs he purchased cost a lot more than that. Does this case turn on whether or not the state can prove beyond a reasonable doubt that factually that the proceeds that were fronted, the money he received for the fronted drugs actually went to purchase the next batch of drugs, next batch of marijuana?
I would say it doesn't, mainly because based, as the Court of Criminal Appeals noted in its opinion on page 6, the state in closing argument argued that the money laundering charges related solely to the money paid to the defendant for payment for the fronted drugs. Mm-hmm. And so the state argued at trial that it was the receiving of those payments that constituted the money laundering charge, not any other disposition that may or may not have been with money. And quite honestly, Your Honor, I would say that there's no evidence that any other financial transaction occurred with those proceeds. We don't know whether Mr. Allison had the sufficient capital or received credit himself.
Well, this case is before us, at least this issue is on the evidence that was presented and whether or not sufficiency of the evidence can be held up on appeal, correct?
Well, yes, Your Honor, that's one question. But I'm also arguing that the indictment in this statute, the way that it was applied in this case allows for conviction simply for the accepting of the payment of drugs. And I don't believe that's the legislative intent in the passing of the money laundering statute. You have to do, and you can accept the money for drugs, but I think you have to find a second separate financial transaction to occur, not just the initial reaping the proceeds of your illegal activity.
So you're basically arguing it's not indicted correctly if the state wants to rely on the purchase of the second or actually third batch of drugs here, correct?
Yeah, that would be my argument is if they were going to allege in the indictment that on Differ's dates that he engaged in money laundering by engaging in separate illegal activity, then that would probably be sufficient, although I would disagree with the policy of it. That being said, I think that in part is our double jeopardy argument is that he's been indicted for receiving these payments on these dates. The evidence at the trial the only financial transaction that occurred on those dates, based on the evidence at trial, is the CI's repayment for the fronted drugs. It's like a credit transaction. You know, every time I repay my car loan, I don't have to go and fill out new financial paperwork. I just pay the original loan off. That's essentially what our argument is that this is punishing him for money laundering for fronting the drugs on credit and then receiving the credit payment. And as the Court of Criminal Appeals argued in their contractual analysis of the sale, I would argue that the CI's repayment of the drugs, repayment of the money for the fronted drugs, was merely his fulfillment of the original sales contract, not a separate transaction from the original contract. Essentially, we're arguing that this is a single transaction that occurred on different dates, or two separate transactions that occurred on different dates.
With Mr. Strong, this is Justice Bivens again. With regard to the sufficiency of the evidence issue as well, what about the language from the Sixth Circuit case, the King case, where it says the payment for drugs may constitute promotion for purposes of the Act when such payment encourages further drug transactions? It sounds like it doesn't even require showing that there were further drug transactions. It simply could encourage that.
Well, and then I mean, I think that is a dangerous language to follow. I don't think it's necessarily precedential in this court. I think that, like I said before, if we allow for the encouragement, then any time a dime bag drug sale occurs on the streets in Tennessee, the person selling the drugs is encouraging the drug trade, and we could indict every drug sale under this B felony money laundering, which is not the way the legislature intended the statutes to be done, by the way they structured the 39, 17, 417, et cetera. And part of me believes that that's where our contention that the money laundering statute's void for vagueness is, that in the language used in it of the carrying on further criminal activity doesn't specify how you could use those financial transactions to carry on anything. I mean, I can conceive of a fraud case where someone reaps the proceeds of some form of fraud, bank fraud or something like that, and then uses the monies to go about and continue producing more fraudulent documents or something like that, or are just going about their daily lives. I don't think that punishing someone twice for receiving the proceeds of criminal activities is the intent of the legislature under the money laundering statute. Whether it's to punish people that make structured transactions or do some way of trying to hide their proceeds, or like the state says, continuing the engaging in in this case, the distribution of marijuana. Again, like I said, there's no evidence in the record that actually occurred. So our position is that based upon the indictment, the way it is written in the indictment, that they had to prove some other financial transaction on those dates of January 13th, 2009 and January 20th of 2009 to support a conviction. They just receiving the drugs alone is not sufficient to support a conviction for money laundering. In regard to the void for vagueness, I would point out it is Justice Scalia wrote in Johnson v. United States, a vague provision is not constitutional merely because there's some conduct that clearly falls within the provision's grasp.
Mr. Strong, would you repeat that? I didn't understand what you said.
I'm sorry. In Johnson v. United States, Justice Scalia wrote that a vague provision is not constitutional merely because there's some conduct that clearly falls within the provision's grasp. It is our contention that the language used by the legislature in the money statute regarding carrying on unlawful activity is not sufficiently detailed as to alert the general public as to what is prescribed by the statute.
Mr. Strong, this is Justice Bivens again. With regard to the double jeopardy claim,
Yes.
how do you propose to get around the specific language of the money laundering statute that talks about a defendant charged with a violation of one or more offenses under this statute may also be jointly charged, tried, and convicted in a single prosecution for any related crimes? I mean, that seems to state a clear legislative intent that there can be multiple convictions here, which is a determinative test for double jeopardy.
I understand that, Your Honor, and our main position would be that a legislature cannot legislate away the protections of the double jeopardy clause by merely saying that because we're going to convict you of that, we can convict you. I understand that under the Blockburger test and like that we're facing a rather large uphill battle, but I would say that in this case, as applied in this situation, Mr. Allison was convicted for two separate offenses for one single act. And I understand that is permitted under the Blockburger test. But in this case, I would say that to be convicted under the money laundering statute, you need a separate financial transaction. And I think this kind of goes back to our sufficiency of the evidence argument that there is no evidence of any separate financial transaction to justify the conviction under the money laundering statute.
You concede that there are elements of one offense, not any other offense for both money laundering and delivery of marijuana?
Yes, Your Honor. I feel I'm in a position where I have to concede that is accurate, but I think as applied in this case to Mr. Allison, the two statutes are punishing a single act in a manner that I think is not constitutional.
It sounds like you're asking us to extend Blockburger to a place it's never been before.
Yes, I am. Were you asking me a question, Justice Lee?
That would be a big leap, wouldn't it, to extend?
It would be a big leap, yes, Your Honor.
It doesn't hurt to ask.
I know I have 11 minutes left, but I think I've said what I have to say. Unless the justices have any further questions, I'll be happy to reserve the remainder of my time for rebuttal.
There's absolutely no punishment for finishing early.
Thank you, Your Honors.
Thank you, Mr. Strong. Mr. Finley?
Good morning, Your Honors. May it please the court, David Finley on behalf of the state. The statute punishes using illegal proceeds with the intent to promote other illegal activity. So the issue here is promoting the other illegal activity. Is the money, the fronted money that the defendant was paid on those two occasions, was his intent to use that to promote other illegal activity? Now, the evidence in this case—
Mr. Finley, this is Justice Clark, and I want to just be sure I understand how broadly or narrowly you are arguing that. Are you taking that position in this case because the credit payment was made on a different day? If he had just received the drugs and paid the money all at the same time, would this charge have been raised? Would he have been indicted for this charge?
Yes, Your Honor, I believe so, because, and the legislative intent is quite clear on this statute, Your Honor.
Isn't the legislative intent clear that you can be convicted of the offense of sale or intent or to sell marijuana, but if you complete the sale, that means you're going to have paid, and that's an offense. So are you suggesting that in fact any small or large sale of marijuana or any other offense automatically becomes two offenses that can be charged in every single case?
Absolutely not, Your Honor. What the intent of the statute is the state has to show a financial transaction that was illegal and the proceeds of which are used to promote another illegal activity. So a dime bag without any further proof that proceeds from that bag were used to promote other illegal activity, the state cannot make that case.
But
Mr. Finley.
Mr. Finley, this is Justice Bivens again. But that then by definition is basically saying that if somebody sells a dime bag and then takes that money, turns around, buys another dime bag, the money laundering statute would apply, correct?
It would apply if the state could prove that, Your Honor. It would. The question.
This is Justice Lee. What evidence do you have that there's a direct link between this $6,500 that was fronted was used to buy the $44,000 worth of drugs?
We have the
direct evidence.
Yes, Your Honor. We have the defendant's own statements on the recordings. When he received the money,
was what? That he's got stuff coming in? Was that basically it?
Yes, when the informant made the first payment for the fronted drugs, the defendant said that he was trying to get his money together. He had 3 or 4 guys coming in. He was trying to put something together. When the informant made the second payment for the second fronted drugs, the defendant then said, "It's come in. It's really good. I've got a lot of it." So we would submit.
How do we know he didn't have other money to buy those drugs with? Because we know $2,460 of that fronted money he still had. And we have to presume that, I think the state presumes that he was doing more drug dealing than just to this informant. So how do we know that the balance of that money went to buy these drugs? Maybe he used it to buy food or gas or living expenses.
Well, we know because he said so, Your Honor. He said he was trying to get his money together to get this deal going, this big deal with the green tub of marijuana. So that's how we know. And that's why the state structured the indictments the way they did. The first 2 were for delivery. And then during those deliveries, when the defendant offered the fronted drugs, and during payment for those fronted drugs, the defendant made these statements. That's when the statement came up. That's when the state came back and charged with money laundering, because those statements indicate that the proceeds, especially from those fronted drugs, were intended to be used in furtherance of other illegal activity. The defendant said a reasonable jury could certainly infer from his statements that the money from the fronted drugs was going towards the big deal he had coming in, which was the green tub.
So for your position, you do not need proof that the money actually was spent for the illegal drugs, because we know a good part of it was not. You just say if he intended, then that's sufficient.
Your Honor, that's the statute. The statute says with the intent to promote the carrying on. There's no requirement that the defendant actually completed it. It's the intent to promote the carrying on. So we would submit that he had the intent to promote the carrying on of illegal activity in this case. And it's proven in this case because he said as much to the confidential informant, and the green tub came in just as he told the confidential informant.
Mr. Finley, this is Justice Page. I want to make sure I understand the state's position here. If all we had in this case was delivery of drugs and part of it was purchased, then some more drugs, marijuana was fronted, and then 4 days later, the informant paid for those drugs, does the state contend that is money laundering without any further proof? In other words,
do your hypothetical again, Your Honor. I didn't quite.
All I'm saying is we have proof that we have fronted drugs that were paid for 4 days later. That's all of the proof we have here. There's nothing about intent or what those proceeds were going to be used for. But it seemed like in your brief, you were arguing that just fronting drugs was good enough to conform to the money laundering statute and cause a conviction.
No, not at all, Your Honor. What the state has to show is that the proceeds from the fronted drugs were intended to be used for other illegal activity. That's the intent. And we believe that the evidence more than shows that. The intent certainly, and in reality, the fact that the green tub of marijuana showed up right on time, as the defendant said.
Tell me what evidence you have showing that this money was going to be used to promote or purchase more drugs, circumstantial or otherwise.
We have the defendant's statements, Your Honor. The defendant's statements. When the informant made the first payment for the fronted drugs. The defendant told him, I've got trying to get some money together. I've got a deal coming in. I got 3 or 4 guys on the road. And the informant made the payment for the second fronted drugs. That deal had come through. Those drugs were on the way, had come in. They weren't in the defense garage yet, but the defendant said, I've got this stuff. I've seen it. They're cutting it out of the gas tank. It's some really good stuff. So, and it was at that point that the police got their search warrant because they rightly assumed that the drugs had been delivered. And the next day, after that second payment, the next day, they observed the defendant bring that green tub into his garage. So while we argue that the statute requires intent to promote unlawful activity, we actually have in this case the actual ongoing activity, the defendant's caught in the act.
But you didn't allege ongoing activity as the offense in the indictment, correct? The state did not.
I'm sorry, Your Honor?
The state did not allege ongoing conduct for purposes of the indictment, correct?
It alleged with the intent to promote the carrying on of the sale of marijuana. That's what's in the indictment, Your Honor.
Well, going back to Justice Page's initial question for a moment, with regard to your position on whether just the mere fact that a portion of the transaction was fronted and paid for later, as whether that constitutes an offense under the money laundering statute in and of itself or not. Wouldn't it have to be your position, given that you indicted on 2 separate counts of money laundering and he was convicted on 2 separate counts of money laundering?
I don't follow your question, Your Honor. I'm sorry. Say that again.
If he's convicted not on 1 count of money laundering here, but on 2, correct?
Correct.
Well, what are the 2 separate offenses, if not each of the times when the money was fronted? And thereby, by definition, you're saying that because they were fronted, that constituted a money laundering.
It did, Your Honor, because he used that financial transaction in each of those instances with the intent to promote the carrying on of other illegal activity. And that's what statute requires. And that's what was shown here by his own words, Your Honor. But
the point is, I thought you answered no to Justice Page with regard to his question about whether simply separating the one transaction into partial payment and partial fronting, that didn't necessarily constitute the money laundering charge here. Did I misunderstand your answer?
I don't think that was my answer. I hope it wasn't my answer, Your Honor.
That's what I thought it was.
Yeah, me too.
If it was, I was wrong, Your Honor.
You want to rephrase?
Mr. Finley, this is Justice Clark, and you can think about that some more. Let me go back to 39-14-903-C1 and ask you about how some of the other language of the money laundering statute comes together.
Yes, ma'am.
It requires, before we get to the intent to promote the carrying on, it requires that the transaction be with a law enforcement officer or somebody as an agent of the law enforcement officer, like this informant.
Yes, Your
Honor. Does that mean that as long as somebody is smart enough or dumb enough, I'm not sure which, to just keep dealing with other druggies, that they are fine? And it's only when they unfortunately happen upon somebody who's a confidential informant sent by law enforcement that they're subject to being convicted also of money laundering?
Not at all, Your Honor, because Section B1 of the statute covers dealing with other people other than law enforcement. So B1 is an offense to knowingly use proceeds derived directly or indirectly from a specified unlawful activity with the intent to promote in whole or part the carrying on of the activity. So that what was charged in this indictment, B1 or C1? C1. Okay. And I think the legislature made that distinction because there were going to be instances where undercover informants or undercover police officers would be doing this. So that's the distinction between B1 and C1.
Let me go one step further, because the first sentence of that section says, it is an offense to knowingly conduct a transaction with a law enforcement officer or agent. And I'm cutting some words out here as I summarize, but what level of knowledge is required to knowingly conduct a transaction with a confidential informant?
Your Honor, I don't think knowingly means you have to know it's a confidential. You just have to knowingly conduct the transaction, Your Honor.
Okay. And do you have any, have our courts interpreted that anywhere before?
Not as far as I know, Your Honor, but I think it's clear from the statute. Otherwise, it sort of seems to undercut the point of the statute. If the state has to prove that the defendant knew that the informant was an informant and knowingly conducted the deal, there seems to be little point to the statute in the first place.
Thank you.
Your Honors, as to the remainder of the defendant's claims, we would submit that there is no double jeopardy violation here. The legislature made a specific provision for this. And regarding constitutionality, the federal courts have looked at a similar statute over many, many years and have found no vagueness. The Sixth Circuit has specifically, the Fifth Circuit, I'm sorry, has specifically found that the phrase carrying on is not vague whatsoever. So we would submit that the double jeopardy and the constitutional challenge lack merit as well.
Counsel, were I'm sorry, this is Justice Kirby. Was the indictment only based on the essentially the later payments for the fronted drugs?
Yes, Your Honor.
It was not based on the initial payment?
It was not, Your Honor.
Why would that not, I'm trying to get my head wrapped around why there is a difference between the two. It gets back to Justice Page's questions. You're relying on a series of statements by this defendant, and I don't understand whether you are differentiating between the payments for the fronted drugs and the payments for the initial drugs. And I'd like you to explain that to me.
Yes, Your Honor. So what happened here, counts 1 and 2 are for delivery of drugs, not for sale of drugs. They're for delivery of drugs.
Excuse me, yes.
Yes. And that, I think that causes a little bit of confusion there, but it's delivery, not sale. Counts 5 and 6 are for money laundering based on the fronted drugs. The reason counts 5 and 6 are based on the fronted drugs, I believe, is because we have the defendant's own words when payments were made for those fronted drugs, saying that he was trying to get his money together because he had a deal coming in.
I thought you mentioned some statements in connection with the first payments as well, sort of anticipating. I'm trying to put those together. Okay.
And that's my fault, Your Honor. I wasn't clear on that point. Those statements were made when he was paying for when he was getting payment for the fronted drugs.
All right. So none of those statements were made in connection with the first payment.
With counts 1 and 2, the delivery, no, Your Honor. Okay. Those statements were made for the fronted drugs, which is why the indictments were structured the way they were.
Mr. Finley, this is Justice Lee. I'm having trouble understanding why any drug deal could not also be a money laundering deal, assuming that the drug dealer, that is his business, and he plows his profits or part of his profits back into his business, and he has no other visible means of support. Wouldn't every drug deal that he or she makes turn into also a money laundering charge?
No, Your Honor, and I think the Court of Criminal Appeals addressed that in Jackson. Simply using your drug money to make your car payment or make your house payment, that is not money laundering. The
Right, I agree with that, but if this is your business, you are going to plow your profits back into your business.
And the state has to show that, Your Honor. And I think that's the distinction here with counts 5 and 6 and the statements the defendant made when he received payment for the fronted drugs.
And you said that's the distinguishing factor here, those statements.
He was very clear. I'm trying to get my money together for this big deal. And so we submit that supports money laundering under the statute.
We don't know that he actually got his money together from this front money.
Well, he's conducting these transactions, these fronted money transactions, to get his money together for a deal.
So it just rests on his intent.
Right. And the statute focuses on intent.
Oh.
This is Justice Page again. He was paid $3,500 on the second fronted drugs. And when he was arrested, he had marked bills that came from that transaction of $2,780. No, I'm sorry, he had $2,780 on him and marked bills for $2,460. So obviously he used some of that money for something else, and what he was buying cost a lot more than that. So how do we consider these facts?
Well, I think that they're relevant in that they go to the fact that we're talking about a matter of 24 hours here, Your Honor. So some of that money has disappeared in 24 hours. And so I think a jury could reasonably infer that it was used in some way in the drug deal. But again, to refocus the court.
Excuse me, this is Justice Clark, how would they reasonably infer that? He might have gone out to dinner or bought a bunch of beer or just stopped and bought bread or done any number of things. There's nothing in the record that suggests what he did with that money.
But we have his own statement, Your Honor, saying he needs to get this fronted money together for this big deal.
You have to prove more than that was his plan, that he actually did it. I mean, for example, this United States versus Heaps case, a 1994 case out of the Fourth Circuit, the court found that there was not sufficient evidence because there was no direct connection between the fronted money and the second drug deal. Did there have to be more than that?
Well, I think there has to be sufficient evidence from which a jury could infer that the illegal proceeds were acquired with the intent to promote the illegal activity. We have the defendant's own statements here saying, I want to use these illegal proceeds in furtherance of more illegal activity, to wit, getting the big green tub of marijuana.
Well, this is Justice Kirby. Back to Justice Lee's earlier question, wouldn't this be present in any situation where you have somebody who engages in an ongoing series of drug transactions? They have no other visible means of support, but somehow they continue to buy and sell drugs.
Well,
I mean, wouldn't that always be money laundering? Even without these statements that you are relying on, those circumstances, it seems to me, would fit what you are talking about.
Well, again, we run into the problem we had in Jackson, where the court said that simply using your illegal proceeds to simply make car payments or other legal disposition of those proceeds.
Talking about where there's proof of ongoing drug, somebody is in the business of buying and selling drugs. They have no other visible means of support. So the only way that they can buy more drugs is to use the proceeds of their earlier sales, at least in part, to buy more product.
If that is in fact the case, Your Honor, then I think that it's a reasonable inference for the jury to find that. But again, there has to be some proof in the record that the illegal proceeds were used to promote the other illegal activity. And we have that in this case, Your Honor. If the court has no further questions, we would ask you to affirm.
Mr. Finley, let me ask you one more question before.
Yes, Your Honor.
Excuse me, it's Justice Bivens again. Other than the defendant's statements on the tapes taken during this time with the confidential informant, is there any other evidence in this record that supports the state's position on the intent issue?
I think the fact that a good deal of that money is not on his person, and there is no, and he said he didn't have that money anymore on him from either the first fronted sale or he's missing some of the second money from the second fronted sale. So we would submit that there is that proof aside from his statements that the money has simply disappeared. And
going back to Justice Clark's
has appeared.
Going back to Justice Clark's point earlier, though, I mean, couldn't that cut the absolute opposite way? That in fact he was using that money for things other than additional purchases of the drugs? Because if he was supposedly saving all of his money for this big drug buy, why wouldn't he have all of it there instead of part of it? So to me, that seems like that cuts almost the other way.
No, well, I think, again, Your Honor, what could a jury reasonably infer? And if Your Honor's excluding all of his statements, everything he said, and we're just looking at what happened here and what amount of money's left, I think a jury could reasonably infer he's in the drug business. He's come into, we're not talking about dime bags here. We're talking about $44,000 worth of marijuana. I think a jury could reasonably infer that that money he made from the fronted drugs was used in furtherance of that illegal activity, was intended to further that legal activity, Your Honor.
All right, very well. All right, is that it, Mr. Finley?
That's it. Thank you, Your Honor.
Thank you. Mr. Strong, your rebuttal? You're still muted, Mr. Strong.
Yes, Your Honor. I'm sorry. I was trying to find my mouse to get over to the unmute.
No problem at all.
I think one thing, it's our contention that you need another financial transaction besides the original transaction. Just accepting the money for the drugs. If you accepted that money for drugs and you were continuing to go buy more drugs to sell some more times, I would say that that's not money laundering at that moment in time until you actually engage in that second financial transaction. And I think the way that this case was indicted.
Counsel, this is Justice Kirby. The statute speaks to intent to promote. So at the time that you receive the money, if you intend at that time to use it to buy more drugs, why isn't that enough under the literal language of the statute?
Well, because it's our position that because the statute also requires a financial transaction. And in our position is it's not the same transaction as the selling of drugs, but a second transaction.
Which language are you relying on? Can you point me in the statute to the language that you're?
Yes, Your Honor, if I can pull the. Sorry, I should have had the statute in front of me.
It's okay. If you can't readily lay your hands on it, it's
I have it here. I have the knowingly conduct a financial transaction involving property or proceeds represented by a law enforcement officer to be proceeds derived from a specified unlawful intent.
But the financial transaction is the receipt of the money for the drugs that were delivered previously, right?
Well, our contention is the statute requires another financial transaction other than just the receipt.
Okay.
Mr. Strong, this is Justice Bivens again. Let me follow up on that then. Well, under that theory or that interpretation, wouldn't there be at least one violation of the money laundering statute here because of there clearly are two separate transactions here. So even if they're not separate convictions, wouldn't it uphold one because of the fact that there were two different transactions on two different occasions?
Well, I think my argument is that the statute our position is the statute requires a financial transaction separate than those two financial transactions, the repayment of the drugs for the previously fronted.
Well, I understand your position is that with regard to the two convictions, but what about if it were just one conviction?
Well, I agree, if he had been indicted like I said before, on diverse dates between January 13th and January 21st, he engaged in money laundering, I would say that conviction might be better, or the indictment would have been better in that regards. But in this case, he's indicted on those specific dates, January 13th and January 20th of 2009, in engaging in money laundering merely for the act of receiving the fronted money. And our position is that just receiving that fronted money even if you had the intent to go out and buy more drugs with it, is not sufficient to justify the money laundering until you engage in that separate financial transaction that's required by the statute.
Mr. Strong, this is Justice Page. The state's position is that there was that next transaction when they had the $44,000 worth of drugs come in, and he allegedly paid for part of it with these proceeds, right?
I think that I think the Justice Lee and Justice Kirby, I think we're accurate in looking at the idea that we have no idea of where this money actually went. He could have given it to his sister. He could have paid his rent. I don't know if there's any evidence in the record that would be sufficient to show that he actually used these proceeds at that time. It's a supposition and maybe it's circumstantial evidence, but I don't think.
We're under the Jackson versus Virginia standard. So if there's any proof a reasonable juror could accept, then we're stuck with it, correct?
Well, yeah, but I go back to my argument in regards to the language of the indictment, that these transactions had to have occurred on January 13th and January 20th. And I think that's our position, is that because of the way it was indicted, that this case, merely receiving the repayment for the drugs on those dates, which is the only financial transaction evidenced in the introduced at trial, is not enough to justify a conviction under the money laundering statute.
Okay. All right. Thank you, Mr. Strong. I know you're just answering questions, but your time is up. So, all right, gentlemen, thank you very much for your participation here today. Again, we realize it's not what any of us are used to, but we're having to have a new normal now. So, and we appreciate you being a part of that today. And with that, we will conclude this case, and we will stand in recess until 1:30 Central Time.